The GDPR was originally adopted in April 2016 but was enforced in the UK in May 2018, when the DPA UK was updated. It was the biggest change in privacy legislation for many years and applies to almost every organisation no matter what their size. It was introduced as we have entered the social media age, meaning our personal data is widely available. Data in essence has become quite lucrative. Some say a new oil. It's because it is so lucrative the GDPR gives people back ownership of their data by pressurizing organizations to protect individual data. It encourages the storage of data that's necessary to the business and restricts the movement of data outside of the EEA. GDPR affects both manual and automated processing and so includes both digital and paper records. It applies to personal data or that is able to identify a living subject and excludes anonymous and encrypted data. It applies to all data subjects. So affects public sector, business to customer, and business to business relationships. The law for processing personal data depicts that the data subject has to have given consent for their data to be used. This could be in the form of an agreement or a contract. The agreement or contract must protect the vital interests of the data subject. Except where such interests are overridden by the data subject, in particular where the data subject is a child. Companies should check their procedures to ensure they cover all the rights individuals have. This includes how a company would delete personal data or provide data electronically. The GDPR includes the following rights for individuals: the right to be informed, the right of access, the right to rectification, the right to erasure, the right to restrict processing, the right to data portability, the right to object, and the right not to be subject to automated decision-making including profiling. So an individual working for a company who keeps data, only share relevant information with trusted colleagues or supervisors who need to receive it. Report any suspicious behavior or activities immediately to your data protection officer or responsible person for it to be investigated. If a person requests their data from your company, you will have a month to comply. You can refuse or charge for requests that are manifestly unfounded or excessive. If you refuse a request, you must tell the individual why and that they have the right to complain to the supervisory authority. If your organization handles a large number of access requests, consider the logistical implications of having to deal with requests more quickly. If your organization operates in more than one EU member state and you carry out cross-border processing, you should determine your lead data protection supervisory authority. We've just covered all the major points of the GDPR. If you're affected by the GDPR, we strongly recommend that someone gets to grips with it and connects this to the DPA UK policies you have in place.